Everyone, please stand for the group. Everyone may be seated. Let the record reflect that the court is back in session and calls number M327556. Case the South State of Texas versus Kimberly Michelle Barton. Let the record reflect that Kimberly Michelle Barton is present in court with her attorney, Attorney Wright Kimler. Let the record also reflect that the state is present with Attorney Andrew Hubel and Attorney Kobe Hoffmeyer. Let the record also reflect that the jury is now present in the courtroom. Members of the jury, the defendant, Kimberly Michelle Barton, stands charged by information with the offense of theft alleged to have been committed on or about the 22nd day of June 2020 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our laws provide that a person commits the offense of theft if she unlawfully appropriates property with intent to deprive the owner of such property. So that you may better understand the nature of the offense which the defendant is charged, I'll now define certain terms and words. Appropriate, as used herein, means to exercise control over personal property. Appropriation of property is unlawful if it is without the owner's effective consent. Deprive, as used herein, means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Possession means actual care, custody, control, or management of the property. Property, as used herein, means tangible personal property or documents, including money, that represents or embodies everything of value or anything of value. A person acts intentionally or with intent with respect to the nature of her conduct when it is her conscious objective or desire to cause the result and had knowledge that the prohibited result will occur. You are instructed that if there is any testimony before you in this case regarding the defendants having committed offenses other than the offense alleged against Kimberly Michelle Barton in this information, in this case, you cannot consider said testimony for any purpose unless you find or believe beyond a reasonable doubt that the defendant committed such offenses, if any were committed. And even then, you may only consider the same in determining the identity of the defendant or the issues of intent, motive, system, scheme, or design, if any, in connection with the offense alleged against Kimberly Michelle Barton in the information in this case and for no other purpose. Now, if you find from the evidence beyond a reasonable doubt that on or about the 22nd day of June 2020 in Jefferson County, Texas, the defendant, Kimberly Michelle Barton, did then and there unlawfully appropriate property by acquiring and exercising control of corporal personal property, namely coolers, owned by Charles Golden, hereafter styled the complainant, of the value of at least $100, but less than $750, with the intent to deprive the complainant of the property and without the effective consent of the complainant, then you will find the defendant guilty of theft as charged in information. Unless you so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instruction. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant's guilt, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution's prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any fact, any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberations, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider the facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not discuss or mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge should subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a full person, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. And the last page is the verdict form. If your verdict is, we the jury find the defendant not guilty, then your foreperson will sign at the top. If your verdict is, we the jury find the defendant guilty of the charge in the information of theft, then your foreperson will sign the line on the bottom. And both lines have below it full person. Does everyone understand? State, are you ready? Defense, are you ready?
Yes, Your Honor.
Now, the state has a right to open and close.
State exercises its right to open and reserves time to close.
Okay, how much time do y'all need? Give you 20 minutes, would that be enough?
Yes, Your Honor.
Okay, so each side would have 20 minutes. Mr. Huber? You can go first,
Thank you.
and I'll be keeping time. You may proceed.
Thank you all for your participation in this process. It's very important to both us as a state and your defendant. So in order to have her day in trial, for y'all to be here to listen to evidence. During jury selection, I went over the elements of the offense with you, and at this point, I'm going to do so again, just to show that based on the testimony and the evidence in this case, the state has met its burden. So first of all, in Jefferson County, Texas, we have established that this theft occurred in Jefferson County, Texas, through the testimony of Jennifer Boyd, of Charles Golden, and of our officer who responded to the incident in Port Arthur. They've also said that this incident took place at the county's coaching operator in Port Arthur, Texas. So all the other can suggest that the offense took place in Jefferson County. On or about June 22nd, 2020, this language on or about does not require an exact date, an approximate date. So as we discussed in this trial, the theft alleged that took place on June 19th of 2020. The information charged says on or about June 22nd because that was when law enforcement responded to the case. So within that 3-day period, which can be seen if you view the video as a timestamp in the top left of that video, is within 3 days of the on or about, which is in close proximity. This was corroborated by the testimony of our 2 store employees, as well as the officer who responded. The defendant, the identification of the defendant has been made confidently by both our store employees who come to testify in this case. They've given various reasons why they were able to identify the defendant in this case, whether it be her body type, her clothing, the way that she moves, the specific behavior that she had with her head whenever she entered the store in order to obscure the view of her face. These were all things that both store employees viewed as calling cards for this particular individual. And they also had a history with her, which was discussed in testimony going back several years, in which she has been involved in several similar circumstances to the case in question, helping them identify her in this case. So based on testimony, it should be viewed that she is in fact the culprit. Our store employees also identified the property that was stolen. In this case, the pair of Yeti coolers. This is, as the charge sets out, purported personal property. And the testimony of both store clerks also identified the value within our frame for a Class B theft, which is $100 or more, but less than $750. So the testimony places the value of these items within that range. And the video show, I'll take intent to deprive and without effective consent simultaneously. The video shows in this case her simply taking the coolers from the display and leaving the store without paying for them. And she does so in a way where, as I asked the witnesses earlier, with no intent to come back and pay for them. She clearly didn't ask anybody to take them for free, and she would not have been given permission to take them for free. She just walked in and saw what she wanted and took it. She had no intention of paying for those objects, for those coolers. And since she did take control of these coolers without the effective consent of anyone from Academy, or specifically in this case, Charles Goldman, who was who had a superior right of possession. She unlawfully appropriated that property. So put simply, on June 22nd, 2020 in Jefferson County, Texas, Miss Kimberly Barton walked into a Port Arthur Academy. She took the coolers from the display. They were within the range of value between $100 and $750, and she left with no intent to pay for them. So with that in mind, with all the testimony and evidence being considered, the state has met its burden and proven that Kimberly Barton has committed the offense of theft plus B. Now I'm going to give Mr. Kimler consent to speak, but I will be speaking to you after he concludes.
Okay.
I get to 15 minutes, Your Honor, would you give me a warning?
Okay.
Ladies and gentlemen, counsel, Your Honor.
Yeah.
Please begin my closing arguments for the court leads off in its instructions where Judge Holmes instructs you that in returning your verdict, it is your responsibility to make certain that justice is done in the case. It's actually the last sentence before you get to the actual verdict form. I would suggest to you that when Judge Holmes instructs you that it's your obligation to see that justice is done in the case, that's not a collective instruction, so to speak, but an instruction directed at each and every individual as individuals. And what it means is that your duty is to go back into the jury room and you get faith, engage in deliberations, and go back and forth and discuss the case and vote what you think is an appropriate outcome, guilty or not guilty. And that after good faith deliberation, voting, consideration of the evidence, that there's an inability to reach a unanimous decision, either guilty or not guilty, that none of you actually surrender what you think is the appropriate vote, be it guilty or not guilty, give that up simply to return a unanimous decision. You vote against your conscience and your reason. There's some sort of requirement or collective responsibility that you have to reach a verdict. It's not a collective responsibility to return a verdict. And what I mean by that is if you go back and engage in these deliberations in good faith and vote your reasoned decision regarding guilt or the absence of guilt, then you've fulfilled your duty to see the justice, not even though you can't reach an agreement. And if you can't reach an agreement, that's fine. We come back and we'll try the case another day. It's not some sort of disaster. So bearing that in mind, each of you individually will consider the evidence, and you'll go back and you'll again hopefully engage in conversation and deliberation amongst yourselves to try to come to a conclusion. If you can't do that, it's not a failure. Now you're able to go back into the jury room and have the evidence, the admitted exhibits brought back to you to look at and consider. And I encourage you to do that. I encourage you to take a second look or third look or fourth look, many times as you want to look at the surveillance video in this case, which is really the crux of the case that the state has presented to you, the basis of the evidence is that video surveillance footage. And look at it carefully, because if you go back and you look at the other evidence that the state has offered, you're going to find that your opinion, whether that video shows beyond a reasonable doubt that it's that individual, is going to be based on the same, if not greater, experience than the state's other witnesses, state's two witnesses, Mr. Golden and Mrs. Flick. And when I say that, you look at what their testimony is, neither one of them on June 19th of 2020 witnessed firsthand this occurrence. They didn't see the person come into academy and steal these coolers. I don't contest this stuff, the coolers stolen. If somebody went in and did steal. But neither Mr. Golden or Ms. Quick actually is an eyewitness to that. What they're doing is that they're going back and saying, well, we've observed Kimberly Barton in the past. We know it's Kimberly Barton because we've interacted with her in the past. We know it was her that we're interacting with this person. And based upon those prior observations of her and watching her, whether how she looks, how she's dressed, how she, her gait, how she walks, those types of things, we're able to compare that with the surveillance video and tell you that we're sure it's her. All right. I would suggest to you that over the course of the 2 days of this trial, you've had the same, if not more, opportunity to view Miss Barton in person, to look at her, to observe her, either whether it's in court or out in the hall. And again, I don't know if you've seen her walk or kind of I'm sure you've observed her out during breaks and those types of things. Sufficiently to look at that video with the same amount of knowledge and same amount of experience regarding Miss Barton and what she looks like and her mannerisms and her clothes and everything else as Mr. Quick and Ms. Golden, or Mr. Golden and Ms. Quick, and come to your own determination if or whether you believe that State's Exhibit 1, the video, is beyond a reasonable doubt Ms. Barton. You have the same, if not more, experience or competence to make that call as either one of the state's proffered witnesses. Because again, they're not eyewitnesses. They looked at the tape and said, based on our prior experience, Martin, we think, sure, well, you're in the same position as they are to make that call. And that's why I say, go back and look at that tape. And you can go back, these two exhibits that we proffer, the answer blown up photographs of the State's Exhibit 1, the video, and ask yourself, do you believe beyond a reasonable doubt that the individual depicted in these two photographs, if you believe beyond a reasonable doubt that it's this person? Okay, that's what you have to decide. And you can take these back and look at them too. I suppose you could even have Ms. Barton stand up in front of you and look at her if you want. That would be a question. To compare if that becomes an issue in your deliberations. And that's really what you have. And you're going to look through these instructions. Well, it's proof beyond a reasonable doubt. But what is that? On the things, it's not instruction. There's no instruction in here. Judge Holmes hasn't told you what. It's not defined it. But as I went over with you in more dire, that even though it's not a definition that binds you, that it's a very high standard. Because we're talking about potential jail time, criminal conviction for theft, the brand of the thief, those types of things. So each of you, again, there's no definition that you're bound by. Each one of you is going to have to determine for yourselves how high of a burden is it? How difficult should that burden be? Proof beyond a reasonable doubt in making this decision whether or not the state's met their burden of proof of identity through State's Exhibit 1, the video, and then looking at these photographs as well. Do you believe beyond a reasonable doubt the person depicted in these photographs and on that video is indeed this point? Do you believe that beyond a reasonable doubt? You may think there's a good possibility it is. I think there's a strong possibility it is. It probably is. I would suggest to you that none of that is beyond a reasonable. Beyond a reasonable doubt is more than that. And I go back to, again, the slide that Mr. Hubel shows you during the statesman are the standards of proof in all cases. This is a higher standard of proof that's employed to take children away from their parents. That's clear and convincing evidence. This is beyond that legal. It's a very high. But it means nothing if you won't give it meaning. If you won't, in your own deliberations, apply that standard of proof, that high degree standard of proof in your actual deliberations. It's up to each of you in good faith to employ that standard as you see fit in the United States. Now, Ms. Barton took the witness stand. Remember, we discussed a little bit more dire about if somebody doesn't take the witness stand as a defendant, but you hold that against them. Well, she went ahead and took the witness stand, testified, and told you that she didn't do this. And you can evaluate her credibility as you see fit, but this is a person that has taken the oath under penalty of aggravated perjury and denied the oath. It's not her. And you can consider that. By doing that, she's opened up a little bit on her criminal history where she instructed you that, or she testified that she had a prior felony conviction for a drug offense. And the court's giving you some instructions regarding prior offenses. It's in here that you can consider that for the purposes of intent, motive, system, scheme, or design. That's some grade as it relates to prior offenses. I would suggest to you that the prior existence of a prior felony drug offense doesn't really implicate any of those, but you can consider it within the parameters of paragraph 3 of the instructions. The other thing too that was significant is by taking the stand, she exposes herself to everything about her criminal history. And the state, in that regard, introduced Exhibit 3, which is a judgment convicting her of criminal trespass. And
You have 10 more minutes.
yes, sir. You recall Ms. Barton told you that she had never been charged or convicted of any theft-related offense. Now, I would suggest to you if that's a lie, if you're misrepresenting that, then Mr. Hubel, Mr. Hoffpower would have shown you a judgment like this criminal trespass where she'd been convicted of theft, or pulled up her arrest record and say, well, you've been arrested for theft. That was her answer, and it wasn't contradicting that. So if you want to consider criminal history, you can, but you can consider lack of criminal history. And she's never been charged or convicted for a theft case today. One other thing that I wanted just to make sure I address and I don't forget is Ms. Quick's testimony. When I talk about, your observations of Ms. Martin being the same, if not more, than the observations made by Mr. Golden and Ms. Quick. One thing Ms. Quick said, or two things she said, as far as the identification, was that she had viewed some sort of enhanced photograph of Ms. Martin that showed facial tattoos. Now, the judge instructs you in these instructions that you can believe all part or none of what a witness testifies to. But I would suggest to you that based upon what Mr. Golden told you and the lack of any evidence offered to you from the state of photographs of the person depicted in states one, any type of enhanced photographs of their face where you can really make that identification. But first of all, they simply don't exist. They wouldn't have been produced. And that goes along as consistent with Mr. Golden told you that it's impossible for them to generate those types of things. So you can infer from that when Ms. Quick told you, hey, I looked at that photograph and she had facial tattoos, that's just, it's either, I hesitate to say a lie, but it's been 3 years, this case has been pending, she can be respected. But it didn't happen, it didn't exist. That photograph does not exist because that contradicts what Mr. Quick or what Mr. Golden told you, and the lack of that photograph being produced. They didn't have the ability to produce that type of photograph from from States Exhibit 1. What she would get would be something like these distorted images. But she was either not telling the truth or didn't remember. The other thing that she stated that would tend to say that she has maybe more knowledge than you to identify Ms. Martin as the person in States Exhibit 1 was that she said the next day, she testified the next day, Ms. Martin came into academy, in other words, June 20th, and had the same clothes on as the person depicted in the video from June 19th. Now, I think, again, if you look at the evidence from Mr. Golden's testimony, that no one would, if somebody had come in on the 20th, and they had an active trespassing warrant and were confronted by store employees, there would have been an offense report generated, which there wasn't. So from that, you can infer, and then again, there's no evidence that an offense report was generated in criminal trespass against the department. Then again, this Quick is either misrepresenting things or over a 3-year period of time, she's not remembering correctly, because if Ms. Martin had gone in to academy on June 20th and been confronted by Ms. Quick, there would have been some sort of report generated for criminal trespass or something of that nature. And we know that she's being prosecuted for criminal trespasses at academy, that something would have been generated to show that she was in the store on June 20th. When Ms. Quick had confronted her. The absence of that is that you can infer that didn't occur. So we're back to being able to say beyond a reasonable doubt or not that the person on States Exhibit 1 is the person sitting in the witness stand. And I would simply suggest to you again, go back, look at the video, and ask yourselves in good faith, can you truly say the person depicted on that video beyond a reasonable doubt is the person sitting right there? That's what you have to answer. If you deny the standard of proof entailed by proof beyond a reasonable doubt. And again, you can also take these photographs back and I thank you for your time and attention to this case. I know that like me, y'all may have looked at a lot of incidents these days about these just mass shopping things that are occurring in our society. And those are wrong. It's a symptom in my mind of a deterioration in society. But I hope that that kind of, I guess, societal situation doesn't influence you just to the idea that anybody accused of shopping. It's an individualized determination. The state's still required to make their to meet their burden of proof in each individual case. And in this particular case, looking at that video, the surveillance video, and the state of the testimony, there is at least reasonable doubt that the person depicted in that video is Ms. Barnes. So I ask that you return to the word.
Mr. Mr. Hubel, you have 14 minutes left.
May I begin, Your Honor?
Yes, you may proceed.
Mr. Gimler, in speaking to you just now, stressed two things in great detail. The burden that the state has to prove its case by, which is beyond a reasonable doubt, and the identification of the defendant. First, addressing the burden that we have to meet. That burden is not beyond all doubt. And as I just addressed with you and went element by element with you a couple moments ago, the state has met that burden in this case. In regards to the identification, as I had earlier urged, our two store employees have done a great job in identifying this particular defendant, Ms. Kimberly Barton. Now taking Jennifer Quick's cards, as Mr. Kim was pointing out, she did identify the defendant in State's Exhibit 1 by her similar clothing, based on the fact that she witnessed in State's Exhibit 1 the events of the 19th, and in person the event that took place on the 21st. She also has experience with Ms. Barton in order to identify her on several different occasions through the past couple of years, as does our other store witness, Mr. Golden. And these incidents are trespassing incidents where she has attempted to take things from the store. Mr. Golden identified the defendant by her body type, by her clothing, and by her behavior in entering the store. As I addressed earlier, the behavior in which she tilted her hat down to where her face could not be captured on the cameras. This type of behavior indicates that she is aware she is good at not getting caught. So whenever she said she's not committed to theft, she's not being convicted of theft, in my mind, that means she's never gotten caught. She's a very effective thief. It just so happens that in this case, she did get caught, and she was identified on video by store employees. And though they did not personally observe her that day, they did identify her based on these characteristics that I've listed in their personal experience with her. Mr. Kimler also talked about how you do not have a responsibility to return a verdict in this case. That being said, you do have a responsibility in this case and oath to follow the law. And as I addressed in my opening and went through element by element, state has met its burden in this case. So I ask that you decide the facts in this case, apply the facts to the law in this case, and return a true verdict in this case. And I ask you, this is what the verdict sheet will look like, to sign this area at the bottom of the jury form, saying that you find the defendant guilty as charged and the information. Thank you all very much for your time.
Thank you, Mr. Hill. Ladies and gentlemen, for the jury, at this time, all the evidence, the court's charge, and the closing arguments are before you. I'm going to hand the bailiff a copy of this charge to be with you in the courtroom. Once all the members of your jury are present and assembled in the jury room, the case is formally submitted to you and you may begin your deliberation. At this time, Mr. Bailiff. Ladies and gentlemen of the jury, please follow the bailiff into the jury room. And this court will stand in recess until the jury has reached the verdict. At this time, you may be seated.